The opening framing matters because this was never treated like a harmless emotional outburst. The second the damage happened during a child exchange, the entire situation shifted into family court territory with criminal consequences attached to it. That timing poisoned everything.
I don't really necessarily have a preference. If you know what the plea agreement is, just go ahead and let me know.
Judge, in exchange for some conditions of probation, the state has offered a criminal or a misdemeanor criminal damage property, domestic violence tag, a Class B non-person misdemeanor. State has advised they are willing to recommend 6 months jail, 12 months court services, probation with all standard conditions, no contact in place with the victim and his property, continue to use Talking Parents program for contact relating the children specifically in accordance with the prior divorce case as well. Restitution is agreed in the amount of $6,997.12. No firearms, costs and fees, mental health assessment per the agreement, and an anger management program. I'm assuming the anger management program, if I'm not mistaken, is the DVOA and the BIP, if I'm correct, the domestic violence offender assessment.
Yes, that would be fine.
Okay.
All right, thank you, Mr. Smith. Ms. Norris, is that your understanding of the plea agreement that's been worked out?
Yes, Your Honor. State would move to amend count 1, the only count in the original information, to a misdemeanor criminal damage to property, and we'd ask that the court add a DV, or that there be added to a DV tag. That is a Class B non-person misdemeanor.
What's the restitution amount that's being proposed?
Your Honor, it's $6,997.12.
All right, Ms. Smith, you've heard the plea agreement that's been announced, is that correct?
Yes, Your Honor.
And that's how you wish to proceed today, pleading, is it a no contest or a guilty plea, Mr. Smith?
Judge, we would request a no plea, but we're satisfied with the basis as set forward in the amended complaint.
All right, Ms. Smith, is your plea being made freely and voluntarily?
Yes, Your Honor.
Has anybody made any threats or promises other than the plea agreement to get you to enter into this plea today?
No, Your Honor.
Do you understand that you have a right to have a jury trial in this case?
Yes, Your Honor.
Or a trial just to the bench? And at the trial, the state would be required to prove your guilt beyond a reasonable doubt on each element of the offense. Do you understand that?
Yes, Your Honor.
And you understand at trial, your attorney would be able to cross-examine the state's witnesses and you would be able to put on any evidence you felt was favorable to your situation?
Yes, Your Honor.
Do you understand that on a Class B misdemeanor, the maximum penalty is 6 months in jail, and the maximum fine is $1,000?
Yes, Your Honor.
All right, Miss Norris, can you provide a brief factual basis?
Your Honor, on August 11th of 2023, at court Andover, Butler County, Kansas, that the defendant did scratch or key the sides of a black Ford F-150 truck, VIN as noted in the information, belonging to Joshua Smith, who is her ex-husband and whom she shares children with. And this was done during child exchange at that address, and there was damage to the vehicle, and it was done without any permission from the victim.
All right, thank you, Ms. Norris. Ms. Smith, have you had plenty of time to discuss your case with your attorney?
Yes, Your Honor.
Do you need any more time to visit with him before we proceed further?
I don't believe so.
All right, I do find that you understand the nature of the charges and appreciate the consequences of pleading no contest. And I further find that you understand the rights you're giving up by pleading no contest, and the facts of the case would be sufficient to sustain a finding of guilt. I will therefore find you guilty of amended count 1, criminal damage to property, class B, misdemeanor with a domestic violence tag. I assume the parties are wanting to proceed with sentencing today.
Yes, Your Honor.
Defense is fine with that, Judge.
All right, and Ms. Norris, I heard the recommendations announced by Mr. Smith. Do you wish to supplement those or provide additional recommendations?
I do not, Your Honor. Those are in keeping with the plea negotiations and basically almost verbatim from the email exchange that we had last week. Thank you.
Okay. Mr. Smith, anything you would add regarding the sentencing recommendations?
Just momentarily, if I may, Judge. Though the restitution was agreed and defense has no objection to its workability, it is a large amount for a period of 1 year. I believe my client fully intends to begin making payments as soon as she is able to. But given that it is a approximate $7,000 amount, I'd request the court to consider that and making any findings as to her payment amount per month, as it would be quite substantial to.
The defense attorney spends most of sentencing trying to soften the financial pressure instead of fighting the jail exposure. And that says everything about where the real danger already sits. Once probation enters the picture, survival becomes about compliance.
Make those into 12 separate payments through a year probation. Thank you, Judge.
All right, thank you, Mr. Smith. Ms. Smith, is there anything that you would like to say before I pronounce sentence?
I don't believe so.
All right, for the sole count of criminal damage to property, the Class B misdemeanor, I will sentence you to a term of 6 months in the county jail. I will place you on probation for a period of 12 months from that controlling sentence with court services. You'll need to follow all standard conditions of probation, including not to violate the law, not to possess or use alcohol or illegal drugs, stay in contact as directed by your probation officer. If you have contact with law enforcement, you'll need to let your probation officer know within 24 hours. I'm going to order that you pay restitution in the amount of $6,997.12 to, that's paid to Joshua Smith. Is that correct, counsel?
That is correct.
All right, I don't believe a fine was requested. However, you will be ordered to pay the court costs and the probation supervision fees. As a condition of probation, you're not to possess firearms. Any communication you have with Joshua Smith should be done through the Talking Parents app. Is that what was recommended in that regard?
Yes, Your Honor, that is it's in consistence with their previous divorce decree, and it seems to be working for them.
All right, and then I want to make sure I'm clear, since there's a DV tag, she will need to obtain the BIP assessment. Is that what was contemplated?
Judge,
Yes,
I think because of the DV tag, the domestic violence offender assessment would be required if I'm not mistaken.
All right, and that will be the order of the court, Ms. Smith. Ms. Smith, can you turn on your camera, please? Ms. Smith?
Let me see if I can call her if it was dropped.
Ms. Smith, can you hear me?
I can now, Your Honor.
Okay, I'm not
The
sure
la-
when you,
The last thing I heard was that if I have contact with law enforcement, I would need to inform my probation officer within 24 hours.
all right, then I ordered that you only communicate with Joshua Smith through the Talking Parents app. Did you hear that?
Yes, Your Honor.
Okay. You're not to be in possession of firearms. You need to obtain a BIP assessment, which is a domestic violence assessment, and follow any recommendations that are made. Mr. Smith, you're retained, is that correct?
Yes, Judge, my apologies. I had myself muted.
All right, counsel, have I covered all of the recommendations that were made?
Your Honor, the only one that the court has not addressed is the mental health assessment, and that she followed through on the recommendations in conjunction with the domestic violence offender assessment.
Okay, is that a separate assessment than the DV assessment?
Yeah, Your Honor, I'm not sure how mental health or South Central or whoever ends up doing it would consider doing it, whether it be separate or if they could do a combined version. But I think both aspects are important.
All right, Mr. Smith, anything you would add in that regard?
I don't have any, because it's part of the plea, I don't have any issues with if the court believes a mental health evaluation on top of the BIP evaluation is necessary. I would note that I do believe mental health is a category, if I'm not mistaken, of the BIP assessment. But I do believe it would be technically a separate evaluation if the court wants a mental health evaluation as well.
I don't want to necessarily bog her down with an unnecessary evaluation. If the BIP assessment includes a mental health component and recommendations are made that are in line with the mental health treatment or med management, I think that would suffice. If it doesn't include that, I think she should obtain a separate one, but I know that can be tricky for a probation officer in trying to determine what exactly she needs to do. So I just want to make sure we make it clear, because there's various types of mental health assessments, that some of which can be very expensive.
I think that as far as specific like mental health and medication management, I think that would be a psychiatric evaluation. There's also just the mental health, which would cover depression and anxiety, things of that nature. I don't think the BIP necessarily, as a quote specific category of its evaluation, includes mental health just as a factor in determining whether or not the person is to complete the entirety of the better intervention program or not, or what sort of classes are required. So to answer the court's inquiry, is
The prosecutor's explanation about the protection orders completely reframes the defendant's image in the courtroom. Up until then, this could almost sound like a bitter divorce situation that escalated too far. After that statement, the court starts viewing the conduct as recurring behavior instead of temporary anger.
it necessarily related to medication management and things of that nature. I do not believe so. But I just meant that I believe it includes some inquiries about mental health for the purposes of determining what classes for anger management are necessary.
All right, I think at this point, I'm just going to order that the BIP assessment be done.
So, Your Honor, you're taking out the caveat regarding the mental health component. If not, then she should have the mental health assessment. Are you removing that from?
Well, it's my understanding that the BIP assessment includes a mental health component. Is that, did I hear?
Your Honor, I've never actually seen the full evaluation. I'm sure they actually ask some questions that are mental health related, but as far as an actual whole section that's on mental health, I really couldn't say. Usually we just get the results of the evaluation that says, do they need the domestic violence offender BIP program and or not, and how many weeks do they think they need to spend in the program? The reason I asked for mental health, and well, domestic violence offender and BIP is required based on the DV tag. So I don't think the court has any choice in that. The reason I asked for mental health as well is because according to, and with documentation and other court documents, this is a long-standing, long-term issue with this defendant and her ex-husband. Obviously, they're not married for a reason, but she's had more than one PFA or PFS or whatever against her out of Sedgwick County. I mean, so I feel like maybe there's something else going on besides, obviously she doesn't like her ex-husband, but people who don't like other people don't necessarily key their car or have to have PFAs and PFSs against them more than once or multiple times. So I suggested mental health assessment and that she follow through on the recommendations, because I don't know how she's going to score in the domestic violence offender BIP assessment.
Okay. And if that was part of the plea agreement, I'll just order the mental health assessment as well as the BIP assessment. But I probably made that way more complicated than I needed to. All right, Ms. Smith, you have a right to appeal this sentence. If you can't afford an attorney to do an appeal, one will be appointed for you. All right, Mr. Smith, are there any sentencing recommendations you feel I haven't addressed?
Judge, does this jurisdiction address payment procedures for the restitution amount as to a schedule of payments or something of that nature? My client's biggest concern is ensuring she's in compliance with the terms of her probation, but that is a large amount to pay off in 1 year. That's the only sentencing consideration I still have.
Can she afford to pay a minimum of $100 a month?
Ms. Smith?
Yes, sir, and I could do that.
Can you make a payment by the end of August?
Yes, Your Honor.
Okay, I'll order there be a minimum payment of $100 a month due by the last business day of each month, starting with August and the last business day of each month thereafter. Obviously, that's not going to get everything paid off. That's a minimum amount. So you'll need to make larger payments along the way, but that at least sets a minimum amount.
Judge, I apologize that I'm inquiring so much about this issue, but I do not practice in Butler County a substantial amount, so I'm not entirely sure how your jurisdiction handles it. In the event that she has not paid off the entire amount of restitution at the end of the probationary period, assuming all other variables consistent, what is usually the court's normal position on that? I just want to be able to advise my client appropriately.
A lot of times it'll be done by a voluntary extension. A lot of time those issues get worked out just by agreement and the court signs off on those. And in worst case
Understood.
scenarios, people will get a warrant to show cause filed on them. But typically the person who's paying and cooperating, it doesn't usually come to that.
Understood, Judge. Thank you very much.
All right, Miss Norris, can you think of anything else?
No, Your Honor, thank you.
All right, Miss Smith, do you have any questions about your sentence?
No, I do not.
All right, you'll need to call court services when we get done here. Mr. Smith, do you have that number to provide to her, or do I need to do it?
No, Your Honor. If you could relay that information to her, I'd appreciate that.
Do you have something to write with, Smith?
I'll take it
Go
down
ahead,
as
Your
well,
Honor.
Your Honor.
316 322 4153.
The ending leaves behind a strange contrast that probably explains why these courtroom clips attract so much attention online. The actual hearing is procedural and emotionally restrained, but the consequences are brutal once you stack them together. Jail exposure, thousands in restitution, probation fees, mandatory programs, restricted communication, domestic violence labeling. None of that came from a violent assault or dramatic confrontation. It came from one vindictive decision during a child exchange. That is the hidden warning running underneath the entire case. Family conflict becomes dangerous the moment revenge starts feeling emotionally rewarding. The court treated the property damage like evidence of deeper instability because the children were close enough to absorb the hostility. That is why the punishment expanded far beyond scratched paint. The system was responding to the emotional environment surrounding the act, not just the act itself.